First, Ms. Goodman, I was asking Attorney Elder if a divorce has been filed, and she's going to now give me the divorce case number.
Yes,
Yes.
ma'am.
Yes, sir. The case number is 2022 DR 00198-14.
-14. And who is that case assigned to?
I literally just found it today, so I did not look to see who it was assigned to. I didn't take down that information, so please forgive me on that. My client has not been served in this matter.
Okay.
Tell me the last numbers again, Judge, and I'll find out. It's in Clayton County, correct?
Yes, ma'am.
It's
00198-14.
Okay. All right, Judge, let me look.
Okay. Now, as it relates to the two witnesses that you intend to call, which are the children of Mr. Nixon, can you give me just a thumbnail sketch of what you expect their testimony to show?
Yes, the children live in the household with both of their parents, as well as their 9-year-old grandchild, which is the daughter's son. They all live in the household, and they are going to testify that there has never been any acts of physical, mental, emotional abuse whatsoever directed towards Ms. Nixon, that their father is actually the peaceful guy in the situation, and that they're actually kind of worried for their mother's overall mental health. Now that, Mr. Nixon has been removed from the home due to the ex parte order, you're going to hear evidence that she has now started harassing her children, calling police on them for baseless acts. This divorce stems from essentially adultery on Ms. Nixon's end. Essentially, people that have iPhones. I don't have an iPhone. I tell people not to get iPhones because all of your stuff attaches to the cloud. And so her adultery was discovered, and the parties are going through a divorce.
Okay, so how old is the person named Aunt Nixon?
That's Anthony Nixon Jr., and he is 21 years of age.
Okay, and the person identified as Anthony Neek Nixon, how old is she?
34 years of age.
Okay. And they both still live in the home?
Yes, sir.
It's assigned to Jewel Scott, and so we will have to hear it.
Okay. All right, so this is now streaming on YouTube. I'm going to have both Angela Freeman Nixon and Anthony Nixon. Please raise your right hand for me, please. Do you swear affirm in the statements you make during this proceeding shall be the truth, the whole truth, so help you God?
I do.
Okay.
Yes.
So I'm gonna read something briefly, and then Ms. Freeman Nixon, as the petitioner, you have the burden of proving your case. Okay.
Yes, sir.
This is a Superior Court of Clayton County. My name is Brad Gardner. I'm a magistrate court judge sitting by designation to hear this matter. The case on this calendar involves a petition for a Family Violence Act, a restraining order under the Family Violence Act. The status of the case at this time is that a protective order has been issued upon the application of one party without notice to and without the presence of the other party. The purpose of the hearing today is to determine whether the protective order will be continued. That may happen in two ways. The first way is that both sides can consent or agree to a continuation of the protective order. If that does not occur, then the petitioner will have the burden of proving by a preponderance of the evidence that the respondent has committed an act of family violence and that there is a reasonable likelihood of future acts of family violence. If the order is continued, it will stay in effect for 12 months. It will automatically expire at that time. The order may be converted into a permanent order only upon the written motion of the petitioner following an additional hearing before the court. If the hearing is continued today, there are a number of other issues that may need to be resolved based upon your particular circumstances, and we'll delve into those as need be. If you have shared the use of any property with the other party, whether it is a residence, automobiles, furnishings, or anything else, the right to the temporary use and possession of the property will have to be decided. If you have incurring obligations to pay debts with the other party, the responsibility for making payments on those debts under the time the order is in effect must be decided. If both sides in your case would like a chance to talk before we have a hearing to see whether you can resolve either some or all of these issues, I will make that time available to you. However, no one is required to engage in settlement discussions. There are allegations of violence in these cases, and if you are not comfortable talking to the other side, you are not required to do so. So, Ms. Freeman Nixon, do you believe it would be useful or beneficial to talk to Mr. Nixon and his lawyer about resolving this case?
Yes, sir.
Okay. Ms. Elder, are you and your client willing to go into a breakout room to discuss resolution of this matter? You're muted.
Sorry, Mr. Nixon, would you like to do that or would you like to proceed, sir?
We can see what we can work out.
Okay.
Okay, I'm going to, it's 3:49 now. I'm going to place you both in breakout room. Let's see, or all three of you in, where are my breakout rooms? I'm sorry. Okay, I'm going to place the three of you in breakout room number one. So Ms. Freeman Nixon, you're going to get a link and I'm going to assign it to you first. And you click on the link and it will place you in breakout room number one. So I just did that. Attorney Nicole Elder, I'm going to put you in breakout room number one. And Mr. Nixon, I'm going to put you in breakout room number one.
I don't know how to work that.
Do you see the link, Ms. Elder? And Mr. Nixon?